Hello and welcome to Byjus Exam Prep IAS. Before we start with our today's analysis, a quick gentle reminder. Byjus Exam Prep IAS is now on Telegram. If you've not yet joined the channel, please do join so that you get all the current affairs related updates. Let's get started and look into the first article. The first article says constitutional silences unconstitutional inaction. Let us try and understand what is this article all about. This article here is speaking about the powers of the governor and the grey area or ambiguous articles in the Indian Constitution. When you look at the Constituent Assembly debate, they did discuss about the constitution in detail. However, few articles had some ambiguous provisions and this was considered to be a grey area. What did the Constituent Assembly decide? They felt that in the near future, the parliament may come together and they may figure out which are these ambiguous provisions in the constitution and ultimately address them. One such ambiguous and grey area is Article 200 of the Indian Constitution and Article 201 of the Indian Constitution. So the Constituent Assembly felt that the Parliament may get together, address all these loopholes that are existing in the Constitution. However, these articles are being misused by the political parties in the present situation without addressing the core issues is what is this article all about. Let us try and understand what is the author trying to speak in terms of Article 200 and Article 201 of the Indian Constitution. When you look into the bare act of Article 200, when a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council, has been passed by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, or he withholds assent thereof, or he reserves the bill for the consideration of the president. There are three objectives that are given to the governor. What exactly happens? A bill becomes an act only when it is given assent by the governor. So he has to sign it. So what should the governor do? The governor has three options. One, he will give his assent to the bill, which means that he has gone through the provisions of this particular bill and he says, yes, this particular bill has to be implemented. So he gives permission to this particular bill. So he assents to the bill. So he gives permission, he signs on this. The second is he withholds the assent. He does not say what is the issue with this particular legislation or the bill, but he just stops himself from signing that particular bill. So he does not sign, so he withholds the assent. That's the second one. And third, he sends this particular bill to the president. So the president will now look into it. That's the end of the story for the governor. So the third is where he considers this bill that ideally this should be going to the president and the president should decide about this particular bill. However, there is a fourth option as well. That fourth option is return the bill. What is this return the bill? Let's say, for example, the governor feels that there are certain provisions in this particular legislation which may not be good for that particular state. So he says that this is what is the issue with respect to this legislation. He asks the legislators to change it, amend it, or reconsider this particular legislation or few provisions in this particular legislation. So once it is sent back to the house, that is to the legislature of the state legislature will reread it, and if they find okay, the governor whatever he said is right, they may bring amendments to this particular legislation, or in sometimes they may also feel no, whatever the provision is right, so they may actually resend back that particular legislation. So when they resend back that particular legislation to the governor has to give his assent to the bill, provided that the governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the house or houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and when bill is so returned, the house or houses shall reconsider the bill accordingly, and if the bill is passed again by the house or the houses with or without amendment and presented to the governor for assent, the governor shall not withhold the assent. So when it is sent for the second time, it is compulsory for the governor to give his sign or the assent to this particular bill. Provided further, the governor shall not assent to, but shall reserve for the consideration of the president any bill which in the opinion of the governor, if it became came law so derogate the powers of the High Court as to endanger the position which the court is by the Constitution designed to fill. What is the grey area or the ambiguity in this article? The article goes on to say that he may withhold the assent, but when a legislators come up together, the houses come up together, they decide something for that particular state, they draft a bill, send it to the governor. Within what time frame should the governor gives the assent? This is not specified in the Constitution. This is the ambiguity that is left open. This is the gray area that is left open. Ideally, this should have been addressed, but unfortunately, there are governors who are taking this advantage and they are not giving the assent. Ideally, they should have given the assent because the state legislatures have drafted this particular legislation. The state representatives are the will of the people in themselves. This also represents the federal feature of the Indian Constitution. But when the appointee of the central government, who happens to be the governor, is not giving the assent, which means he's not giving the signature to this particular legislation, keeping it for a long period of time, when he'll give the assent is yet not notified. This is the gray area. There is a lot of discretion that is given to the governor, which is being exploited by the political party, says the author. And the author goes on to give some examples. The examples range from Tamil Nadu prohibition of online gambling and regulation of online bills 2022, which was passed by the Tamil Nadu Assembly, and Kerala Lokayukta Amendment Bill 2022, passed by the Kerala Assembly, but this is not given consent by the governor. Ideally, he should have given it, or you should have notified when he's gonna give it, or you should have said what are the changes that needs to be introduced. Nothing. The assent is not being given, and the Constitution should have ideally mentioned before which the governor should have given the assent. But since that is the gray area, he is exploiting it, is the concern the author tries to put out. In Tamil Nadu alone, almost 20 bills are awaiting assent by the governor. The situation is no different in Telangana and West Bengal as well. Now let's look at what happens in Article 201 of the Indian Constitution. Bill reserved for the consideration. When a bill is reserved by a governor for the consideration of the president shall either declare that he assents to the bill, that is, he signs the bill, and that he withholds the assent, provided that where the bill is not a money bill, the president may direct the governor to return the bill to the house, as the case may be, the houses of the legislature of the state together with such message as it is mentioned in the first proviso to Article 200, and the bill is so returned, the house or the houses shall reconsider it. Accordingly, within a period of 6 months from the date of receipt of such message, and if it is again passed by the houses or houses with or without amendment, it shall be presented again to the president for his reconsideration procedure in the financial matters. Again, the gray area is when should the president give the assent, before what time he should give the assent. That is yet not mentioned in Article 201 of the Indian Constitution. So this basically means that this gray area, the ambiguity in the provision, is being exploited by the governors in multiple states in the country. When you look into why this article was introduced, we have to look at the important asset as to why governor is appointed. When you look at why governor is appointed, he wears two hats. One, he is appointed by the central government. He is also the executive head of the state government. Why is he appointed by the central government to the state government? That is because the state governments at times may take some of the legislations, they can come up with some of the legislations which might be against the union laws. So the governor, who is in the executive position, would be able to see this, and he would also be able to tell the state governments that you are contradicting the union law, so please change it. This is one of the ideas why this particular provision, or why governor is present, and why 200 and 201 is present. That is, a reference is being made to the president, and at the same time the governor is also keeping a constant check about the constitutional principles as well. What if the state government is taking away certain powers of the High Court? In that particular case, the governor would be able to refer this particular legislation to the president so that he can take a look at it, which is why we have Article 200 and 201 of the Constitution which is present. And at the same time, when you look at Section 75, so Section 75 of the 1935 Act, we have the Government of India Act of 1935. When you consider this provision, it was also present in the Government of India Act of 1935. It contained the word in the discretion of the governor, but this was completely omitted when we consider the Indian Constitution as well. So when you look at why this provision was introduced in 1935 Act under section 75, we had this provision which was already present. The same was imported into Indian Constitution as well, but then in the discretion of the governor, which was present in section 75, has been deleted under 200 and 201 of the Constitution. So when the draft of the article was also discussed in the Constituent Assembly, we had Professor Shiban Lal Saxena, who rightly highlighted that there is no time limit prescribed for the governor to act, and this happens to be the major problem, says the author. What has the Supreme Court said? In Purushottam Nambudari versus State of Kerala, a constitution bench of the Supreme Court clarified that constitution does not impose any time limit within which the governor should provide assent to the bills, and at the same time it also went on to clarify that when you look into the constitution clearly marks that the governor will have to listen to the Council of Ministers. The governor works on the aid and advice of the Council of Ministers. So whatever they say, the governor will have to listen. So if the assent is not given, this very fundamental of the governor and the Council of Ministers relationship is getting violated. And at the same time, we know for the fact that federalism is part of the basic structure, and basic structure means that you also have the central government which has its own share of power. Federalism clearly points out state have their own share of power. State governments have the will of the people. If the will of the people represented by their elected representative is not respected, the governor is also violating federal principle, which is also meaning that he is violating the basic structure doctrine as well. So causing delay to give assent is an arbitrary exercise which is constitutionally abhorrent, says this article. So how do we overcome this particular issue? This is where the author goes on to say that we have to reform. In a consultation process, the institution of governor under the Constitution, Justice B.P. Jeevan Reddy led committee states that if the governor withholds assent to a bill indefinitely, such a course will not be conducive with the decorous regard a governor is expected to the rules of the constitutional game. So everyone is expected to act with the principles and ethos of the Constitution. If the governor does not give assent to the bill, he is violating the constitutional ethos, said Jeevan Reddy led committee. The National Commission to review the working of the Constitution that was set up by A.B. Vajpayee government in 2000 recommended that there should be a time limit, say a period of 6 months, within which the governor should take a decision whether to grant assent or to reserve a bill for the consideration of the president. So he has to decide within 6 months, says the National Commission for Review of Constitution. And the Sarkaria Commission went to the extent of suggesting a cure to the terminal illness plaguing the federal ecosystem of the country. It suggested delay from the side of the governor in granting assent can be avoided by streamlining the existing procedures, by making prior consultation with the governor at the stage of drafting of the bill itself, and by prescribing time limits for its disposal, which basically means even before the legislation is sent to the governor, these Council of Ministers will have to give a clear-cut idea of what this legislation is. They also will have to say what are the provisions that they are wishing to incorporate, take the permission from the governor, and ultimately introduce this so that there are no issues between the governor as well as the Council of Ministers and the legislature, so that everything is disposed as soon as possible, says the Sarkaria Commission. In Kshem Megha Chandra Singh versus the Honorable Speaker, Manipur Legislative Assembly case on anti-defection law, the Supreme Court held that the Speaker must act on disqualification petitions against the defective MLAs within a reasonable time. So what is the reasonable time before which the governor will have to give the assent? We have to know the meaning of this reasonable time. So according to this judgment, it went on to clarify that reasonable time is nothing but 3 months in the case of disqualification petitions. So can we draw a parallel, a corollary from this, and also say that the reasonable time for the governor to give the assent is about 3 months? Let's draw a parallel with this judgment and gone to conclude that within 3 months the governor will have to give the consent to this particular legislation. So this article goes on to conclude that the constitution clearly has identified that the governor will have to listen to the aid and advice of the council of ministers. So he has to give the assent within a reasonable time is what is this article all about. Now let's look into the next article. This article says fighting the menace of online gambling. Let us try and understand what is this article all about. First, we have to understand why is the online gaming industry booming in India. That is because of multiple reasons. One, what we have of late is the affordable mobile phones and the internet. So access to affordable and high performance smartphones, high speed internet on the go has been a blessing for all, especially for the youth as well as for the companies and the businesses. So businesses are able to give out their service, businesses are able to produce a particular product, and because there are smartphones where all of us have it, that has become the major reason as to why gaming industry has seen a boom. So people are able to download the games because they have the smartphones, and at the same time companies are able to export their services to such people. Second, people have become technologically aware, citizens leading to early adoption of the gaming system. Third, evolving technologies have accentuated the viewing and gaming experience on the mobile phones, which means to say they have much better resolutions, they have much better bigger screens as well. They also have much better computing ability. All this means they have much better optimum gaming experience. This is another reason why gaming industry is seeing a boom. With the advanced and increased adoption of UPI and other fintech innovations in the country, it is not only easier for customers to transact easily but also safer. Let's say for example, when it comes to games, most of us would download the games, and at the same time few people also play games for the sake of transaction and money as well. So if a person is playing one of the games where he has to send money, it is easy for him as well. He can put up his UPI code, he can put up his UPI ID, transfer certain amount from the banking system to this particular application, and also pay the money to this application as well. So because transaction has now become easy, UPI transactions have now become easy, it is easy for this person to send money in this gaming application. Advertisers can effectively target audiences which already play games with authentic branding messaging as well. Now that they know who are the ones who have downloaded their message, they can constantly keep sending messages as well, so that these people actually continue to play their games. These are the possible reasons when it comes to the gaming industry in India. So in a nutshell, what we have is digital India, where most of us have smartphones. That is why gaming industry is on a boom. Then there is digital divide, which is comparatively reduced over a period of time. There is IT boom, young population, high disposable income, inexpensive internet data, new gaming genres, as well as smartphone and tablet, which is why what we are witnessing is the explosion of the online booming industry in the country. Now, Tamil Nadu as a state has banned the online games. Why is Tamil Nadu banned the online games? That is because of multiple reasons. Due to online gaming, innocent people, mainly youngsters, are being cheated, and some people have committed suicide as well. As per an official estimate, in the last 1.5 years, 32 persons died by suicide, and there was one case of murder as well, which is why Tamil Nadu government feels that we have to regulate it and impose a ban on the online gaming. Added to it, they have also realized that when it comes to the gaming, it is a source of addiction as well. People spend at least 6 to 7 hours on this particular gaming, and they're not focusing on the studies. Who are the ones who are constantly on the gaming? It has to be the students. So ideally, students should be engaging in the schools. They should also be active participant in sports as well, but instead of doing all this, they are entering themselves into the compulsive gaming, and their performance in school and other areas have also dropped considerably as well. Then we have number of other games. Let's say for example, we have the PUBG, we also have the Blue Whale challenge as well. These are the incidents which have actually increased violence and suicides, and at the same time, these people who constantly keep seeing the videos, I mean they constantly keep playing as well, such situation has also created short-sightedness for number of youth as well. Added to it, there is cheating, privacy violations, abuse, bullying that takes place, which has resulted in suicide. So to prevent it, what we have is the Tamil Nadu government, which has come up with the legislation, and this particular legislation was sent to the governor. So the Tamil Nadu governor, BN RN Ravi, has chosen to remain silent on the fate of Tamil Nadu prohibition of online gaming and regulation of online games bill, even 4 weeks after the ordinance on the same subject lapsed. So the Tamil Nadu government referred this particular bill to the governor, but the governor has not acted on this particular bill. We just discussed about Article 200. One such example is this, where Tamil Nadu government had referred this bill to the governor and the governor has not acted on this particular bill. So what were the provisions of this particular legislation? As per the general prohibitions, no bank, financial institution or payment gateway provider shall engage in any transaction or authorization of funds towards payment for any online gaming or any online games of chance, geo-blocking, restricting users from accessing online content, online applications or online services based on the user's geographical location. So if they are based out of Tamil Nadu, they should not be able to access this online game, any form of wagering or betting in cyberspace by using computers or any communication device, common gaming houses and electronic transfer of funds to distribute winnings or prize money has also been banned as part of this legislation as well. In fact, they have also imposed penalty when it comes to such online gaming as well. But despite all this, despite all political parties supporting a ban on the online gaming, we have DMK, which is the government which has introduced it, but then the governor has not given assent to this particular legislation. The ordinance has also come to an end as well, and as the ordinance has come to an end, what exactly is happening? As we discussed, there is targeted advertising which is also meeting all these people. So once the advertising continues, people will be lured towards this particular gaming, and ultimately it can lead to more suicides as well. So because this particular legislation has not been given consent by the governor, it cannot be executed. But there are other laws which they can currently make use of to stop the online gaming, says the author. This legislation was referred to the governor. Only when the governor gives permission, when he signs it, that is when it will become a law. They would be able to impose a ban on online gaming. But this is not given permission by the governor. So what are the other laws that we can make use of so that the implementation of the online gaming does not happen in the state of Tamil Nadu? For which the author has suggested multiple other laws as well. What are those? One is the Central Consumer Protection Authority. The matter can be taken to the Central Consumer Protection Authority, which notified 6 months ago guidelines regarding the prevention of false or misleading advertisements and making endorsements. So in the present situation, we did discuss that advertisements are targeting such youth, and as a result, the government can release a notification saying that such advertisements are misleading in nature and ultimately bring them under the loop of Central Consumer Protection Authority. They are not able to make their state law successful. So why not you make use of the central legislation? Because this central legislation already bans misleading advertisement. So bring them under this particular ambit so that it does not become an effective one. Though the norms have been issued, keeping in mind the sensitivity and vulnerability of children to advertisements, an aggrieved person can approach the CCPA if he or she regards any advertisement on online gaming as misleading. After all, the guidelines aim to protect consumers' interests by bringing in more transparency and clarity in way of advertisements. What if they are violating? In that case, according to Section 21 of the Consumer Protection Act, the CCPA can impose a penalty of up to 10 lakh on manufacturers, advertisers, endorsers for any misleading advertisement. For any further contraventions, penalty can go up to 50 lakh as well. For subsequent violations, the ban can extend up to 3 years as well. So what they can make use of is the Consumer Protection Act. Then this can also be labeled as e-commerce website. So all those companies which run their businesses on the online platform, so categorize these online gaming websites also as part of e-commerce. Besides, an online games can be regarded as falling within the definition of e-commerce. The activist says law authorizes the central government to take measures to prevent unfair trade practices in e-commerce and protect the interest and right of the consumers, bring them under the ambit of the e-commerce and declare such advertisements as unfair trade practices, and one would also be able to regulate it is another recommendation. So this article goes on to say that one thing that we can do is give awareness to the people, throw them live examples as what has happened in the past. If the awareness is given and yet not fulfilled, in that case you can make use of these laws that are already existing, is what is this article all about. Now let's look into the next article. This article says dark patterns on the internet, how companies are tricking their users. This article is once again saying that privacy on the internet platform is a myth. Let us try and understand what is this dark pattern all about. Let's assume for a moment you want to read something, or let's assume for a moment that you want to get a service of one of the websites. So what do? They ask you for your credit card information, and they would say they would not be charging any amount from your credit card. You should be able to use a free trial for about a month or about 90 days, and only after that they would take your consent and ultimately charge whether you want to use this particular service or not. But in most of the cases, what happens, you would say that you would continue to use this free trial for about a month or about 3 months, but without your permission they will charge on your credit card. That is an example of dark pattern. Let me give you another example. You have this particular website. The option says that you can opt for it, don't opt out, don't opt in. All this, it will be clear cut, you will be able to see it. But there will be few parameters where you would not be able to see it, that is opt out all. This is in the gray color so that you are not able to identify it. This is an example of dark pattern. Let me give you another example. You have all these e-commerce websites. These e-commerce websites may sell shoes, mobile phones, clothing, so on and so forth. They put up a notification on the website saying that within 59 minutes or 49 minutes or within 2 or 3 minutes this entire program would be taken off within a certain period of time, so that they are tempting you to buy a product within that period of time. This is an example of dark pattern. Or let's say another one where you go onto a website, you're reading something and there's constant message that keeps popping on your screen. This is an example of dark pattern. Or for example, you go to one of the websites, you're reading an article, then there is a video that is playing on the side of the website without you giving permission to it. The consent is not given. Despite that, the video continues to play on that particular website. That is what is called as dark pattern. So we have internet based firms who are tricking users to agree to certain conditions by clicking on something. That is what is called as dark pattern. So dark pattern basically are design elements on the website which basically forces a person, misleads that person, deceive a website visitor so that this person actually opts for that particular service. So the unsuspecting users would now have to accept this, and this happens to be a deceptive tactic, says this article. So the term is credited to UI UX researcher and designer Harry Bringnell, who has been working to catalog such patterns and the companies using them since 2010. Let's take some of the examples. Amazon came under fire in the European Union for its confusing multi-step cancelling process in Amazon Prime subscription. What exactly happens? If you want to buy Amazon services, it is easy. But if you have to cancel their service, it is a long, complicated process. This was identified by European Union, and ultimately the cancellation procedure was made simple. This is an example of dark pattern. In social media, LinkedIn users often receive unsolicited sponsor messages from the influencers. This is an example of dark pattern. In Instagram, what you actually see is that you get some sponsored videos as well, and at the same time they are unable to permanently set preferences on Instagram. What are the kind of reels that you would want to watch? This is an example of dark pattern. Another dark pattern on the application is sponsored video, small sponsored label. This is an example of dark pattern. Google owned YouTube, nags users to sign up for YouTube Premium with pop-ups obscuring final seconds of a video with the thumbnails of other videos, a way of disrupting what should have been an otherwise smooth user experience. All these are examples of the dark pattern, says the author. So basically, you have the countdowns on the online deals like just we discussed. We have 59 minutes, 45 minutes, half an hour, 10 minutes within which you have to buy the product. All the scheme or the program will be completely taken off. So the countdown is a dark pattern. Then there are conditions in the fine print, but cancellation buttons are hard to see. Then you have ads that come up, auto playing videos, after free trials, dull colors. All these are examples of dark patterns, says this article. When dark patterns are introduced, what is it? This happens to be an unethical user interface design. Basically, this particular information is making that particular user coerce or inform that particular person you have no way to exit this particular website, and it forces that person to give all the information, and ultimately it violates the privacy of an individual as well. Or you would go on to one of the newspaper outlets or to one of the newsletters, you would subscribe to their newsletters, and after a considerable period of time, despite you unsubscribing to the newsletter, you still keep receiving that particular newsletter on your email ID. That is once again nuisance as well. That is an example of dark pattern. Despite you unsubscribing it, you keep getting the emails. That is an issue of dark pattern. So this can also be used in a vulnerable situation where children can make use of such services, and there have been ample examples where these children have also been charged and the parents are in a state of shock. So this ultimately means there is violation of the privacy, there is unethical user interface designs, there is financial and data exploitation. So this article goes on to conclude that we have to choose such websites and such services which do not make use of such dark patterns. Now let's look into the next article. This article says Justice Department says raising judges retirement age may benefit non-performers. So this article in brief goes on to say as of now when it comes to Supreme Court judges, the retirement age is 65 years. For the High Court it is about 62 years. If the retirement age is increased, there are few non-performing judges whose numbers go on to increase, and ultimately we would not be able to take them off the system. That's the first disadvantage. Second disadvantage is if this particular process of increasing the retirement age happens, this can also have the cascading effect as well, whereby you would have the government employees who may go on the strike, and they may also appeal for increasing the retirement age of the government employees. So if you do it for the judiciary, the High Court and the Supreme Court, then you will have the government employees who would also request for the same. So this will be cascading effect. So new jobs and new people will not be part of the system. That's the second concern. And third concern is that when it comes to all these people, that is the retired Supreme Court judges or the High Court judges, they are also part of the tribunals as well. If these people are not retired, then we will have crunch of resources, human resource in the tribunals. So this article goes on to say that this very proposal or idea of increasing the retirement age for the Supreme Court judges, High Court judges should not be considered, says the Department of Justice. Now let's look into the mains practice question. The Constitution is silent on a time frame for gubernatorial assent or rejection of a bill. In the light of the statement, explain the relevant provisions of the Constitution and suggest reforms. Why is the online gaming industry booming in India? Discuss the reasons for Tamil Nadu government banning online gaming. So please write all your answers on the comment section, peer review, and do give positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.